Just to pause there for a moment, it sounds to me like you're edging right up to the Solicitor General's test. Am I missing something?
I see the intuitive appeal of the government's test. I think the government, and we are both asking this question of how do you encounter discrimination on a website? And this goes to the analogy Justice Sotomayor was making. Our position is, well, in the physical barrier context, you encounter that accessibility barrier when you visit the hotel, regardless of whether you want to stay at the hotel or what your underlying motive is. So when we translate that into the internet context, we say you encounter the accessibility barrier when you go to the website and click around.
Well, so that maybe that's the difference. I just want to make sure I understand what the difference is. That's all I'm trying to do. The government says, yes, lack of information can be a form of discrimination.
Yes.
When you have some plans. Now, how concrete that is, good luck,
yeah.
All right? But some interest in making a reservation. And the extreme, the other end of the spectrum, I think that, I don't know where you are on this, is I'm just clicking around to see. And I'm looking for an absence of information. I'm going to seek out this discrimination without any plans, without any interest. It's just what I do. Is that standing in your view?
Yeah, so I think that is the distinction between our position and the government's position. So
yeah,
the government
so what's wrong with the government's position?
So I think, so just to articulate what I think the government would say about your hypothetical is the government says you have to use.
Not my hypothetical.
Yeah. The government says you have to use the website in some way. So they would, I think, say our position is akin to driving by the website, and they want you to engage with it and actually make a reservation or engage with it in a way that shows you're considering making a reservation. We say in our brief, I'm not sure that distinction holds as a practical matter. Judge Newsom made this.
No, I'm not sure that's going to be much of a pleading barrier if you were to adopt the government's position versus your clients, I think. But I'm just trying to understand what the real difference is, if there is any, or whether you're comfortable with the government's position.
I'm comfortable with the government's position so long as it's understood as an inquiry into what you experience on the website and not your underlying motive for being on the website,
right,
and not whether you experience any downstream injury as a result of being on the website. And I think that's the real problem with Acheson's position. They are attempting to upend, I think, how this court has always defined discriminatory injury, which is the injury is in the dignitary harm. You don't have to show some sort of downstream consequence.
I appreciate that, but just so I've really got it. The government says the motive's irrelevant. We don't care why you walk in, but we have to have some further engagement rather than just I'm spending the afternoon clicking through these things because that's what I do.
Yes, I think that's right. They think our clicking around is equivalent to driving by and that making the reservation.
Something a little bit more.
Yeah, I think that's right.
And you're comfortable with that?
I'm comfortable. I think it's compatible with Havens.
Okay.
Right?
Yeah, thank you.
Well, that's what